A North Carolina Sheriff's Office says that it'll no longer accept ICE detainees in its detention system, and they say it's all related to a new law stemming from the Queen City. So this is in Alamance County, about 90 minutes northeast of Charlotte. Iryna's Law, named after the woman who was stabbed to death in the Charlotte Light Rail system in August, made changes to how counties now manage pretrial release, electronic monitoring, and the detention of people charged with violent crimes. And because of this, the Sheriff's Office says it must prioritize the resources. Joining us now is Chief Legal Analyst Clive Rhodes. First, let's walk us through so people can know exactly what we're talking about here. That changes December 1st because of Iryna's Law.
Well, let me start with this. Mecklenburg County, if you don't recognize it, if you're not involved in the criminal justice system, everywhere else in the state calls us the great state of Mecklenburg. Why? Because things happen here and they may change the entire state, or we'll do our own thing different than the state. And so, yes, you talked about what happened on the light rail and how that sparked changes to pretrial release, but we can even take it a couple of steps back. When we made our pretrial, changed our bail policy here for what pretrial release looked like back in 2018, 2019, when I had an integral part of rewriting our bail policy. What happened? Our CMPD and other lobbyists went to the General Assembly and asked for changes to be made to pretrial release. That made change for the entire state. Who could be released by the magistrate at the time? Well, this stabbing occurs, and now what happens? The General Assembly does the exact same thing. Lobbyists from Charlotte and across the country go up there and request changes to pretrial release, shortening even now, limiting more the types of charges that magistrates can set conditions on release or. So what does that mean? In practice, it sounds good to not have a magistrate set conditions for release, but in places like Mecklenburg County, Wake County, and other places that have higher volume, if you're not releasing them with the magistrate, that means they're sitting in jail.
Right.
So if these folks are sitting in jail, you only got a certain amount of beds. So if I got 100 beds, and you know, before I was almost at capacity, before you passed this thing in December, and now I'm over capacity, I don't have room to hold these other detainees. What's a detainee? That means that this person is in jail. They've been set some conditions for release, and now you're asking that I hold them, this detainer, for 48 hours. Where am I going to hold them at? If I don't have a place to hold them, because now you've overcrowded my locations where I would hold normal people, because when the magistrates are letting folks out, they're coming in and they're getting out and they're getting a new court date. That process has now changed. So now these folks are sitting and they're waiting until they see a district court judge. They're sitting, that waiting. They have to wait, they have to sit, they need to eat, they got to sleep, you got to put outfits on them. It's a numbers game. If we're counting beans, you don't have enough beans, you don't have enough rooms. So now this is what they're saying. If we have to prioritize, we're going to pick prioritizing and keeping these folks that we know are charged with criminal charges that are violent and are dangerous to our society. We'll keep them in here. And these detainees, we'll let them out. And you guys can go pick them up somewhere else, but you won't be able to keep them here because we don't have the space.
So my question is this, from a legal standpoint, Khalif, when you look at this, does the County Detention Center have the authority to refuse ICE detainees, even temporarily? And could there be some pushback here?
Yes and no. I mean, so there is law on the books passed in the wake, again, of Mecklenburg County deciding with Sheriff McFadden to not work with ICE. That what did our General Assembly do? Pass a law forcing sheriffs that they needed to work with ICE to ensure that they complied with detainers. And so, looking at numbers, looking at what just locally what they do here, there's a number of folks that have been detained, and only a small set of those folks have been picked up. I looked at one number, this is a few months ago, 99 folks had been detained and requests for ICE detainer, but only 30 of them had been picked up. So that meant 66 of them would have been released at some point, but they have sat there throughout that at least 2 days to wait to see if ICE or someone from immigration will come and get them. That process, I think, opens up the door for a sheriff to say, hey, if I know the statistics are unlikely that they're coming and get these folks anyway, I'm going to have to go ahead and let them out. Does it put them in a really unique position to be in compliance with Iryna's law, but also be maybe out of compliance with what the General Assembly requires them to do with compliance with ICE? It does.
Wow. Clive Rhodes, appreciate your insight as always. Thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.